rise. The Court of Appeals, Division 1 is now in session.
Good morning. Please be seated. At this point, I will tell you, if you want to take your masks off, you are 6 feet apart, please feel free to do so. I'm going to take mine off so that you can hear me a little bit better. Additionally, I'd ask you to argue from a seated position. That way you stay on your side of the room and you stay on your side of the room, and we're all safe that way. Sound like a plan?
Yes, Your Honor.
Okay.
Yes, Your Honor.
Good morning. We're here for oral argument in cause number CV20-0031, Discount Payment Services, LLC versus Applied Merchant Systems West Coast, LLC. These proceedings are being video and audio recorded as well as live streamed, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes to present their argument. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal should you choose to do so. Also, we have read the briefs, we have conferenced this case, and are familiar with the facts. Please take that into consideration during your presentation. At this point, counsel, are you ready?
Yes, Your Honor.
Please proceed.
Good morning, Your Honors, Judge Winthrop, Judge Campbell, Judge Swan. I'm Al Arpad for the appellants. Have not previously argued in this court from a seated position, so that's a little unusual, but may it please the court, I feel like I'm at a little bit of a disadvantage. I frequently represent appellants, but I'm usually not in the position where I feel like it's the other person who needs to explain why the trial court could feel free to ignore the written contract. Accordingly, I'm going to ask to reserve 5 minutes for rebuttal, roughly, if I can. In reviewing for this, one of the things I looked at, one of the many things I looked at, was the transcript, which is fairly short, of the oral argument. And honestly, I'm not sure that I can do that much better than my colleague, Mr. Hallstrom, in summarizing this in a very, very short period of time. I thought he hit all of the high points. This case seems a lot more complicated than it is. There are a highly detailed set of contracts between the parties. They're interlocking. They have to be seen as an entire transaction. It doesn't make any sense unless you look at it that way. The transactions involved merchant accounts in the credit card industry that generated income. There's a collateralized loan, which is collateralized with these accounts. There's a loan payoff generated from the collateral that's being held. There's an option to purchase the collateral after payoff. There's a form of purchase agreement. Seems complicated, but the core of it is much, much simpler than that. The core of it really comes down to this 1.5-page supplemental agreement that was signed towards the end of the repayment period of the first loan. The document said that if the option to purchase part, not all, but part of the accounts was exercised, the collateral would change hands at closing when everything was done and the payments and the documents had been exchanged. My client owned the accounts throughout that period and was supposed to receive the excess payments until closing. That's in substance and in form. The documents say he's the owner, they define him as the owner, and he's the one taking all the business risk throughout that time. That's why this was probably structured as a loan. The lender's taking virtually no business risk. My client has to personally guarantee these payments over time, even if the collateral blows up somehow. So my client is the owner of those accounts throughout this period, which means that the loan payments are being deducted, and then my client gets the excess all the way through until the lender exercises the option, until and unless the lender exercises the option and closes on the deal, and then they become the owner of these accounts. There's been some discussion of what are the accounts. Well, the substance of the accounts is a stream of payments. This is all very financialized stuff, but the law is that can be a thing that you can use for collateral. The other piece of it is, as I said, the business risk. You can have clawbacks. You can have, it's all credit card transactions that come in 1 month, and then the accounts settle out, and my client or the lender gets paid the following month. Somebody can come back and say, hey, I didn't really mean to buy that boat, I'm contesting it, and then you can have a problem. Those things are all addressed in the documents. So coming up within a few months of the end of this loan payment period, the parties agree to a supplemental agreement for early payment. And the supplemental agreement is very clear that the only thing it's providing for is early payment of the purchase price. Pretty much everything else remains the same. They slightly accelerate the closing time. And the transaction documents as written say, until we close, my client gets these residual payments, gets the account payments every month, except for what needs to be used to repay the loan. There's been talk from the other side that and the judge decided that that's when the loan really closed, that they became the owners upon paying that purchase price early. There's absolutely nothing in the documents to support that, and there's absolutely nothing in the facts to support that. There's been talk about, well, there was this concession since you had to finish paying off your loan. We agreed that those loan payments would be deducted for a few months. But it's not just that. My client continues to get the excess coming out of being generated by the accounts through that time. My client gets everything. He gets the credit for the loan payment, plus he gets the excess. When it finally came time that the loan was repaid, that's supposed to then trigger the option exercise period. The parties have agreed that notice has been given by this early payment. The parties have agreed that there is an early payment. There's still paperwork that needs to get done, and there's still critically the particular accounts, because this is way over collateralized. There's way more accounts being held as collateral than what the lender is going to be able to exercise the option on. So there has to be a specific list of what's actually going to change hands in order for the transaction to close. And the documents say my client continues to get the excess until they close. So it goes back and forth. There's a short period of time, a couple months, not really out of line with what originally was anticipated, that this might take 30 plus 45 days, something like that, to get it all worked out. The parties had said they hoped to get it worked out quicker after the supplemental agreement, but that's not how it worked out. I don't think my client's at fault whatsoever for why it didn't work out within the couple of months. But for whatever reason, the lender, option E, says that, well, I don't want to pay you those interim payments that accrued during that time period between when the loan was paid off and when the document closes. My client says, well, you have to. I object. I'm not going to sign it. Lender tenders a form of purchase agreement that says, no, this really changed hands back in July. My client says, no, it didn't. Now, the lender has raised the issue of waiver. My client then goes into radio silence for a period of time, except he calls up once in a while and says, where are my excess payments that are being that are supposed to be paid out? I don't think that's particularly surprising when you look at the situation. My client's entire livelihood is being held as collateral for a second, much smaller loan and option for another 8, 9, 10 months after the first one's paid off. He didn't want to poke the bear during that time because of exactly what happened a year later in 2018. Once the processor gets wind that there's a dispute over where these payments are going, everything gets shut down, and my client doesn't get paid anything for a year and a half. So he was not eager to get into that level of dispute. But when it came to litigation, that's the level of the dispute they got to. Can't quite see my clock from the seated position here. So the trial court said that Applied paid its money, Applied gets the merchandise. That would make sense if this was the farmer's market and I paid $1 and there was somehow a dispute over whether I should get my tomato. Yes, I should get my tomato. That's not the situation that we have here at all. What we have is a very complex commercial transaction. From our point of view, it's extremely difficult to tell what the value was that is being exchanged, but there's a whole series of things happening over time, payments being made. There's no reason why this $172,000 payment that's made very late in the transaction should suddenly upset everything and get us to disregard the documents. That makes no sense. In a commercial transaction like this, the parties knew best how to structure their transaction. A judge simply should not come in and turn that around and say, no, I know best. I'm going to change everybody's expectations on this. If you do that, you are seriously harming people's ability to privately structure their transactions. There's been a lot of talk about what it took to exercise
Let me
the option.
just ask you, sir, do we really have a legal dispute here or more of an accounting dispute? I mean, it seems like a lot of the elements of this transaction are not subject to dispute, right? Everybody agrees the option was exercised. The question is, how much was it worth?
Well, my side did take the position that it was not exercised. My side took the position that you had to do several things to exercise. The other side says, no, you only have to do one thing. I honestly think that's an open question. I think it doesn't matter that much.
Well, let's assume for a moment that you only had to do the one thing and the option was exercised, as it appears to have been acknowledged, at least in one context in the record, right? So assume for a moment that the option was exercised. Doesn't that then boil down to a question of just apportioning who's entitled to these residuals, to pieces of these residuals?
No. Surprisingly, there has never been a problem that I'm aware of in this case in working out the accounting. Once the parties got the decision from the court, they were able to sit down and say, okay, working off of what the trial court decided, you get this much, I get this much. The dispute is over. What is the effect of them refusing to pay this set amount of money that would have accrued over a short period of time before they closed the deal? And my client was being super cooperative and waiving. Yes, Your Honor.
3 months.
Basically. I mean, it depends on when you think the deal should have closed, and that's why we didn't give an absolute number throughout this.
But we're basically talking about 2017, November, December, and January. That's what.
Yes.
That's what this dispute is over.
There's some confusion in the record because the loans paid off in November using funds that were generated in October. And so I think my client was initially saying November, and what he kind of meant was November generated stuff that would have been paid in December. So you can say it's November, December, January. You can say it's December, January, February. But yes, there's a kind of a 3-month period where they're going back and forth. My client's still trying to be cooperative and saying, but the contract says you've got to pay me these residuals. And I'm assuming that his numbers are correct for December and January. I haven't gone back and looked. That's not in the record. But it's tens of thousands of dollars. The question then becomes, what's the remedy for that? My client, since the beginning of the lawsuit, once the lawsuit was filed, says, okay, I'm done. I think I'm entitled to have these things back because you never closed this deal. It's been repudiated, and since the beginning, we said wasn't exercised, but we also said repudiated. We also said material breach. We said we're electing out.
From my understanding of the facts, Applied wanted to exercise the option, indicated they were going to exercise the option, provided the list of accounts. What else were they supposed to do?
They were supposed to then provide a portfolio purchase agreement form that doesn't say, by the way, we get to keep your residuals for this interim period.
So did your client offer a PPA that said that?
He didn't write one up. He sent them a fairly detailed letter that says, no, I can't say that. It needs to say I'm getting the dollars for these months.
And so they were precluded from exercising the option because they couldn't sign off on the documents? What was Applied supposed to do to exercise the option that they didn't do?
They should say, we will pay you those residuals for those few months, and as time went on and it was a dispute, it became more months because they still haven't closed. But they've got to have a document that says when. I mean, it's not just my client who's being a jerk here. The third-party processor, as we found out a little later when the dispute becomes hotter, the third-party processor has to know who to send the money to. And so it's got to change hands at a specific time. And if my client had signed that first version, it says, well, actually, the time was last July. So he could potentially even owe a refund of money that he's already been paid based on that. So, of course, he says, no, I'm not going to sign that. Now, if the other side had come in and said in February, in March, okay, I see your point. We'll pay you for a couple of months of this because you're right about this. That could be, then we'd have an argument about what to do equitably in this situation. That's never, ever happened. They have maintained throughout this, no, we're just going to keep your money. We're allowed to keep your money, we're going to keep your money, and we're not going to give you any other alternatives. And I mean, there's no indication anywhere that they have ever offered to close, and every month more of these are accruing. And my client has a claim to more and more of them. I mean, that's just the operation of the documents and the operation of the various common law remedies that we've talked about, whether it's that they failed to exercise the option strictly in accordance with its terms, or whether it's repudiation, or whether it's a material breach. Any of those at some point give my client the option to say, okay, I'm not playing anymore. You have failed to close this deal. And it's a material part of the consideration for the contract.
But the amount of, what troubles me, though, is this transaction seems very carefully structured to represent an economic reality of this loan, right? Parties were very admirably specific about how they wanted this loan paid back, and the option was part of that transaction. Why would an administrative delay suddenly affect the economic substance?
Frankly, that's in the nature of options. I mean, there's no question, and we won on the option 2 because there was an administrative delay that they didn't do it within the time period. They had to do it within 30.
That's a binary question of whether it's exercised or not. But I'm saying, if we engage in the assumption we discussed before, which is that the notice of exercise was valid and closing was something to happen later, the delay in closing, it seems to me, is unrelated to an otherwise very carefully conceived economic model for this transaction.
In a sense, but the very carefully conceived economic model says, okay, if there's a delay in closing, my guy gets the money in the meantime, and your guy doesn't. And if you don't like that, you can hit my client with a $50,000 penalty, and that's your remedy. You can back out and you get $50,000. It's very carefully constructed, and it says my client gets the money until the closing. And we weren't the ones who prevented the closing. That's exactly correct. And it is in the nature of options that if you don't do it right, you lose your rights. That's not a big surprise, whether you call it exercise or you call it something else. I'll reserve the rest of my time, if I may.
Thank you.
Your Honors, may it please the Court, Craig Waugh with DLA Piper for the appellee Applied Merchant Systems West Coast LLC. There are a few aspects of this case that I would like to address, Your Honors. I'd like to address the exercise of the option. It appears from the reply brief and from Mr. Arpad's comments that the exercise of the option is likely not actually in dispute at this point, but I think there are important points to resolve there, or at least for me to highlight to you, because it hasn't been completely conceded. I'd like to also address the arguments that Applied anticipatorily repudiated the purchase and sale transaction that materially breached the contract. And then I'd also like to briefly address the waiver argument that we made in the answering brief. I think before I start with the option exercise, I'd like to return to the point about the closing. So a lot has been made of the closing contemplated by the option agreement and its attached form of portfolio purchase agreement. Those documents were put together along with the loan agreement in 2013. And the argument that you've just heard focuses on the parties didn't actually close the purchase transaction. So even if the option was exercised, I believe the reference was there's still paperwork that needs to be done. There's still a transaction that needs to close afterwards. If Your Honors look at the actual portfolio purchase agreement, the form attached to the option agreement, it describes the closing very simply as the consummation of the transactions contemplated by that portfolio purchase agreement. That document is substantively about the exchange of rights to residual payments on credit card merchant processing accounts in exchange for the purchase price, the money. The closing is described as, on one side, on Applied side, delivery of the closing funds, which is the purchase price originally $90,000 that was negotiated to $72,000 in that supplemental agreement that you heard about. The obligation on the other side from DPS is to deliver full and final rights to those residual payments. By the time the loan was repaid, the option had been exercised by virtue of the supplemental agreement, and as part of that supplemental agreement, the purchase price for the closing was actually tendered and delivered to DPS. It received the performance that it would expect at the closing on the portfolio purchase agreement. And there's no dispute about that. It's acknowledged in the actual supplemental agreement, and it's been acknowledged and agreed to between the parties in the record below. I do want to talk about the option exercise because it was a fundamental primary principal argument in the case below. This was their strongest and lead argument. The option was not exercised. And the reason that they focused on that is because under Arizona law, there's an argument that if one doesn't exercise an option specifically as required under a written contract, the transaction to purchase is forfeited. It vanishes. And so they made a very strong argument, not on its merits, but forcefully, that the option was never exercised because Applied only sent a notice of exercise, a notice of intent to exercise the option, but didn't take subsequent steps like timely selecting merchant accounts that would be purchased, signing the portfolio purchase agreement, all of which DPS argued was required to exercise the option. The trial court rejected that handily, easily. DPS is clearly wrong. The option was exercised. Providing the notice of intent to exercise was all that was needed to exercise the option. Mack v. Coker instructs that Arizona courts look to the language of the option contract to decide what's required to exercise an option. Section 1.02 of the option agreement is clear. The option may be exercised by company Applied delivering a notice of intent to exercise to owner. The other steps described in the option agreement describe the subsequent sale transaction, the purchase and sale transaction that would be triggered by exercising the option. And Max v. Coker goes on to explain very well what happens when an option is exercised. It creates, whether or not there's a draft portfolio purchase agreement or contract in form that exists, whether or not that exists, the exercise of an option creates a bilateral contract for sale. You're no longer faced with forfeiting your right to purchase. You're now in a transaction where you have two sides, each with an obligation. One to pay, one to deliver the property. By the point, and really simultaneously with the exercise of the option in July 2016, the performance of payment was made. That was part of the deal. The only thing remaining at that point is the actual assignment, permanent assignment of residual rights. As we explained below and as we've explained in our answering brief, there was already a permanent irrevocable assignment of the residual rights. And of course, it was security for the loan agreement. It was also security for the option agreement and for the obligation to conclude the option agreement sale if the exercise was proper. But the assignment was already in place. And as Judge Thomason correctly noted, all of the documents, including the loan agreement at section 3.1a, they describe the retention of that assignment and those residuals once the purchase price is paid. Anything that's not purchased would be assigned back. But even the form portfolio purchase agreement, that doesn't require any additional assignments or deliveries, except for what Applied might request or its attorneys might request. And on that same note, at the closing that you heard about, in addition to the delivery of the purchase price, which had already happened, the only other deliverable that day, as described in the form portfolio purchase agreement, would be delivery of any conveyances and documents requested by Applied, if there were any. The point, Your Honors, is that the transaction, the substance of the transaction was completed, and at least Applied's performance of the purchase was complete before the loan was even repaid. And Judge Thomason clearly saw that and applied the logical result, which is that once the loan was repaid, once the merchants were agreed upon, these are the purchased merchants as the term is in the contracts, Applied is entitled to the residuals it purchased with its delivery of the purchase funds months earlier. I do want to touch on, and I'll just note that the answering brief, we referred to several cases, Mack v. Coker, Henderson v. Jacobs, Andrews v. Blake, Phuket, multiple that stand for the proposition that a notice of intent to exercise is a routine and pretty common requirement to exercise an option. It's not as if this is a unique situation in contract. I want to touch on the repudiation point. I think the record needs to be corrected on the reply brief and the remarks you heard earlier. The loan was repaid in November 2016. November 16th, the residuals were paid to Applied, and those residuals satisfied the loan. The next month in December, once the next month's residuals came to Applied, Applied sent a statement to DPS and said, here are the residuals we received, here's our selection of merchants for the purchase, here's the excess that you're entitled to, right? And that's all of the residuals minus the amount that they selected to purchase, minus the $2,000 some that was secured for loan 2. There was an objection by DPS to the account selection method, and DPS allowed Applied to change the selections. And it's been stipulated that there was a waiver of any timing requirements to select merchants and to close the PPA. The next thing that happens is that Applied sends a revised list of merchants on January 10th, 2017. And that list is stipulated to by DPS. At that point, DPS says, and this is in the record at document 35, it's exhibit B5 to Applied Statement of Facts. Applied sent on January 10th, 2017, a list of the revised merchants that was agreed to and stipulated to. These are the ones that the purchase funds will purchase the rights for. And at that same time, there was a discussion about the portfolio purchase agreement. And although in the reply brief and what you heard this morning, there was a representation that Applied anticipatorily breached its obligation to sign that form agreement by inserting terms, the first revision of that form portfolio purchase agreement came from DPS. And if your honors note the difference between exhibits 10 and 11 to DPS's summary judgment motion, that's where they cite to counsel's letter to DPS and counsel's red line back to DPS. That's record number 24. That's in response to what they sent. And the original form of the portfolio purchase agreement is attached to the complaint. So that's document 1 in the record. Exhibit 3 to the complaint, that's electronic pages 78 to 110. That's the option agreement with its attachments. And electronic pages 85 to 96 is the actual original form portfolio purchase agreement. Its section 1 ends at 1.3. The form that came back to Applied from DPS added a section 1.4, a complete insertion on their part. And it was titled Pre-Closing Requirements. And what they purported to do in there is say, well, we agree on the selected merchants, but we propose to you, we'll sign this portfolio purchase agreement with this new section 1.4 that acknowledges that you've paid us $54,000 before closing. And we're not going to move forward and close this deal unless you do it. That's what came back. Now, in response to that, Applied sent back a red line to that document and changed to say, here's what we're willing to do. We're willing to acknowledge that it was structured effectively. We're not going to pay back $54,000. We've been entitled to those residuals since the purchase price was paid and after the loan was satisfied. But what we will agree to do is to reflect in this document exactly what we do have to return, which is the balance of all residuals that came in minus the amounts for the purchased merchants as of the date that they were paid for, minus any amounts needed for loan 2. But there again, the case law, United Bank versus Prudential, Thomas versus Mauna Lucia Villas, is clear about what constitutes anticipatory repudiation. There needs to be a firm commitment. We are not going to perform under any other terms. That came from DPS. We insist upon this, and to this day they say that they refuse to perform without that new Section 1.4. The revisions back in the other direction were, here's what we're willing to do. The email that the revision was sent with, please provide any comments at your earliest convenience. There wasn't a rejection of, this is it, our way or the highway. We asked for comments. No response came to that. Followed up later on. And counsel for DPS is copied on these communications. Followed up in March 2017. Gentlemen, I don't appear to have ever gotten a response to the attached. Please let me know as soon as possible where you stand on this. Again, silence for over a year. And that brings us to the waiver. If there was a requirement that this transaction cannot exist, but for a signed portfolio purchase agreement, which we reject that. I think that their behavior excused us from having to perform any obligation to deliver a portfolio purchase agreement because they said we're not going to do it unless you get back $54,000. But what happens next is their silence continues for over a year. The vast majority of the portfolio, of the residuals assigned to Applied was this list of purchase merchants. Beyond that and the $2,000 for loan 2, there was not much going back to DPS. This is the vast majority of the residuals. And month after month for over a year, an accounting is sent and payment of the excess is sent to DPS. They receive it, and they say not one word about we're entitled to this between $18,000 and $20,000 a month. They make no protest. They never disputed the legal position provided to them by Applied in response to their position that $54,000 was owed. They never did. They never responded to the revisions to the portfolio purchase agreement that were proposed. They never objected that the $18,000 to $20,000 a month was being kept and withheld. And they communicated with Applied during that period of time. In March, April, at least November, December 2017, they reached out about the residual payments, the excess payments, but they never said anything about the payments for the purchase merchants. They gave up on that position. And there's at least an issue of fact if it's not clear enough that they waived any obligation on Applied side to sign the portfolio purchase agreement, there's at least enough to show an issue of fact that would preclude their request for summary judgment on remand, that they waived any obligation to sign the portfolio purchase agreement by their conduct. Judge Swan, you asked if this case was really about an accounting. The record is clear about the dollars and cents involved here. The support for Applied summary judgment motion and the declaration of the CFO of Applied, Clay Hunt, lays out exactly with supporting documents, spreadsheets, and so forth, how much came in which month, how the true up after the account selection was paid. And the trial court correctly found that Applied fully reconciled the amount of money that it received, the amount of money that it reverted back to DPS, and there was no dispute that somehow there's more that would be owed. The question really is, at what point does this transaction close? And
is that the question, or is the question at what point do your rights vest?
I think they're almost one and the same. And
Well,
Your Honor, I think
don't-
that the answer is that they vest when the purchase price is paid.
I think anybody who's gone to a closing might disagree, because when you go into the closing, you walk in with a feeling of vested rights before the closing happens. In most commercial settings, we wouldn't get to a closing unless there were some vested contractual rights already in place. And so while I don't mean to split hairs with you, I do think in this case it kind of goes to the core of your dispute, because we use the term closing a little colloquially and a little loosely. It seems to me that the key events are effective exercise of the option and vesting of contractual rights. Would you agree?
I think those are absolutely in play, Your Honor.
Well, I think they're exclusively in play, and if I'm viewing it too narrowly, I'd like you to tell me.
I do, Your Honor, I do agree that the exercise is an issue, a core issue of the case, and then the vesting of rights is a core issue in the case. And what we have argued is that the rights vested upon payment of the purchase price.
Right. I mean, it seems to me that your argument extended to its ultimate limit would be if closing never occurred, the result's basically the same. Because we exercised the option, we paid the purchase price, the economic substance is now determined and our rights vested.
That's correct, Your Honor.
So even if there were no closing today, your position would be the same.
That's right, Your Honor, and that's what the trial court held as well. You don't need to have a formal closing in a transaction like this. The performance by our client was given, the accounts were stipulated to. There's no dispute about what the intent of the transaction was. The form agreement provides exactly what rights would transfer. I mean, there's no dispute about the identity of the property, what rights would be transferred, that the payment was made. The closing itself would just be a ministerial act. It's unnecessary at this point.
Then why require a PPA in the first place?
Your Honor, it was structured so that the purchase price would be paid at the closing and wouldn't be paid earlier. And the portfolio purchase agreement has, I mean, it's some 6-7 pages long. The parts about delivery of the purchase price and so forth are on the first 2 pages. The rest of it is for the protection of applied, because it has reps and warranties, indemnification. It has agreements that nothing has been done to impair the accounts during the period of time since the loan was made. There are several provisions in that form for the protection of applied. And I would argue that at worst they risk losing those contractual protections without having the signed PPA, but not the sale.
So there was nothing that Discount got from the PPA besides the purchase price and the identification of the portfolio of accounts.
That's absolutely correct, Your Honor. And the identification of the purchased accounts is required under the option agreement to take place before execution of that portfolio purchase agreement. So literally the only benefit to DPS under this portfolio purchase agreement form was delivery of the purchase price at closing. And I've read it recently. I read it this morning before I came here. Your Honors will find that there is nothing else for DPS's benefit in that contract. And if it thought otherwise, it had the right to seek specific performance enforcement of that obligation to sign. It didn't.
All right, counsel, your time is up.
Thank
you.
I'll start with that last point about vested rights. We have absolutely agreed throughout this that they had vested rights to close on the specified terms. They did not have a vested right to say, but we're not going to pay you this money that we're required to pay you under the contract and we still want to close. That's not a vested right in any type of closing that you can say, no, we're not going to take that last step and pay you the money and we still get the res.
I think you're taking my question in a different direction than it was intended. My question was really directed to the relevance of a formal closing and whether we should even be using that word to evaluate this dispute. Because I think it subsumes a few too many concepts that we use in the industry that it doesn't serve us well to conflate those concepts, which is why I was trying to break them out. I'm not suggesting that there is a vested right to breach a contract.
And that's what I think is critical. This is not just a technicality. The way the contract is structured, my client absolutely could not have gotten away with just running around and refusing to sign the purchase agreement and then eventually, oh, sorry, this was for our benefit and therefore that in itself is a material breach and we get to keep all the money. It's refusing to pay the monthly interim residuals that are clearly required in the contract. That's the breach. They didn't have a right to do that. And I agree with Mr. Wall about I didn't hear anything in that recital of facts that I disagree with. The fact is my client said you got to pay this and they said no, we are not going to pay this. And my client sent a back letter saying yes, you are going to pay this. And then the letter stopped because my client wanted to continue to get his residuals in the interim. as best he could. And then as soon as the second loan was paid off, which had kept the accounts in the collateral status, he went and tried to unilaterally change it, said, I think I'm entitled to this stuff back. So that's not a waiver. There's no waiver there. The difference between the original assignment and the purchase agreement, the critical difference is who the business risk is on. All of the business risk is on my client throughout the loan term and the collateral agreement. What the loan says is that all your rights are security, and then what the assignment agreement says is that the payments we have an absolute right to the payments, and you assign them to us, and we're going to get them. But that's clearly a security assignment for a loan in which all of the business risk that I was talking about earlier is still on my client. At the closing, and the only reason it's important is not because of what we think of when we think of real estate closings or any other kind of closings. It's important because that's what it says. And what it says is not consummation of the transaction. It says the exchange of documents and the consummation of the transaction is the closing. And the contract says that's when my client's right to the residuals end. If the contract said something different, then it would be something different. That's why that closing date is important, not because I'm a real formal type of guy who really thinks closings are important. I have very little time left. I just want to emphasize that we did not receive the full performance. That's the whole point. We got the $72,000, absolutely. We did not get the final payments that we were entitled to, and that's what prevented it from closing. And yeah, they were required to pay that. And that's why it didn't close. It's not because my client's trying to get out of the deal. My client went above and beyond, waiving the 30-day, saying, okay, fine, we'll close the deal even late. But when it became clear they weren't going to pay him, he was done.
Thank you, counsel. We thank you both for your arguments. We will take this matter under advisement, issue a written ruling in due course. At this point, we will take a brief recess to reset the courtroom.
Thank you, Your Honors.